Buying a restaurant is a dream for many. A chance to run your own show, serve up your vision, and build a legacy. But beneath the excitement lies a maze of legal terms that can make or break your deal. If you miss one detail or misunderstand something in what appears at first glance to be legal mumbo-jumbo, you could be stuck with deal terms you didn't expect. A lease which gives the landlord the upper hand, or any number of problems. This is not legal advice, but a common-sense guide to basic phrases you should know. They aren't just jargon. They are your toolkit for navigating the restaurant buying process with confidence. APA, Asset Purchase Agreement. The APA is the beating heart of your deal. It spells out all the terms, including exactly what you're buying. Unlike a stock sale, the APA focuses on specific assets, leaving the seller's liabilities behind. It lists the purchase price, the assets included, warranties, e.g., the fridge works, and conditions for closing, like lease approval. Work with an attorney to tweak the APA. Add clauses like seller pays off debts pre-closing. 2. LOI. Letter of intent before the APA comes the LOI. A non-binding starting offer. It outlines price, timeline, and contingencies like financing or lease review. Think of it as a handshake with structure, but a vague LOI can backfire. If you don't specify key contingencies, like liquor license transfer, you might lose leverage later. A certified restaurant broker may suggest skipping the LOI and going straight to an APA with contingencies to lock in the deal while performing due diligence. 3. Escrow. Escrow shows you're serious. It's money held by a neutral party, usually an attorney, until deal terms are met. You're not handing cash to the seller directly, and they're not handing over keys prematurely. In restaurant deals, escrow is critical. For example, a $20,000 deposit may be held until the lease is assigned, equipment passes inspection, or licenses transfer. If the deal falls through based on contingencies, you get the funds back. Escrow provides protection for both sides. 4. Due diligence. This is your investigation phase, usually 15-30 days to verify what the seller claims. You'll review P&Ls, tax returns, sales reports, leases, permits, and licenses. A buyer once skipped due diligence on a bistro and inherited a $10,000 HVAC repair. Set a deadline, make a checklist, and enlist a broker or accountant. This isn't optional. It's your chance to dodge a lemon. 5. Special stipulations. Standard contracts don't cover everything. Special stipulations are customized clauses that address unique terms of your deal. Maybe the seller agrees to stay 60 days for training, or you operate under their liquor license for a set time. These stipulations must be specific, measurable, and time-bound. If it's not in writing, it won't happen. Use stipulations to cover transition details and other post-closing obligations. Chapter 6. Schedule of assets. This is the detailed list of what's included in the sale. Equipment, furniture, POS systems, etc. If it's not listed, it's not included. One buyer assumed 5 deck ovens were included but found 2 were missing. Walk through with the seller, take photos, and confirm what's owned versus leased. This is the stuff that generates your revenue. Make sure it's accounted for. 7. Payment terms. These outline how you'll pay. Cash, financing, or a mix. Key details include down payment, interest rate, and repayment schedule. For example, you might pay $100,000 cash with a $50,000 seller-financed note at 5% over 3 years. Restaurants often involve seller financing to bridge gaps or ease buyer cash flow. Tailor this to your projections. 8. Confidentiality. A confidentiality agreement protects the seller's business during the process. It prevents word from leaking, which could scare off staff or customers. Sign it early, before due diligence, and stick to it. One buyer violated confidentiality by bragging publicly and lost key staff before closing. Don't risk the deal. Chapter 9. Governing law. This determines which state's laws apply in case of a dispute. Typically, it's the state where the restaurant operates. Why it matters? Contract interpretation, lease laws, and liability can vary dramatically by state. Confirm this clause matches the restaurant's location and check with your attorney. 10. Lending contingency. This clause protects your deposit if financing falls through. You're not locked in, and your escrow is safe if your bank declines the loan. List a specific deadline to provide financing proof. One buyer lost $25,000 when his lending contingency expired, and he hadn't even applied. Apply early. This clause gives you time, not a guarantee. Bonus term. Time is of the essence. This phrase means deadlines in the contract are strict. Miss one, and you could be in breach, even if the delay is minor. Pay attention to all key dates in your deal. These 10 phrases, APA to lending contingency, are your crash course in buying a restaurant. They're not just words, they're guardrails that keep your deal on track. Work with a certified restaurant broker to apply these terms in real-world deals, and always consult an attorney for legal review.